Hi everyone, my name is Lizzie Chan, and I am a member of the CPR Institute's Young Leaders in Alternative Dispute Resolution Steering Committee. I am delighted to host today's episode of the Y-ADR Corporate Counsel interview series. Y-ADR seeks to educate the next generation of leaders on the full spectrum of dispute prevention and resolution mechanisms, and to provide an insider's view into how CPR's community of corporate counsel, law firm counsel, and other experts in the field are using dispute resolution and prevention techniques to manage conflict to enable purpose. As part of this goal in this interview series, we will ask corporate counsel to share their perspectives on dispute resolution mechanisms and to share their advice for young practitioners. Today, I am very happy to welcome Nick Barnaby. Nick is the Staff Vice President and Associate General Counsel at General Dynamics, based in Virginia. Hi, Nick. We're so happy to have you today. Thank you so much. Could you please tell us a little bit about your background and your role at General Dynamics?
Sure. I guess I am a lawyer here at General Dynamics Corporation's corporate headquarters. I look after a lot of our sort of significant litigation and investigations matters. I've been here for about 3 years. Prior to that, I was a partner at Jenner & Block's Washington, D.C. office, where I did internal investigations and litigation. I've also practiced at Latham & Watkins and have been really focused on litigation and investigations here at General Dynamics for the last several years.
Do you have a preferred approach for how you resolve disputes, and why or why not?
I think that most disputes, and this is really largely speaking for Nick Barnaby rather than for General Dynamics as a corporation, but at least from my the way that I approach it and the way that I think about it, and I think our company thinks about it, is that there is not a sort of particular one-size-fits-all approach to dispute resolution or to the proper forum or format for resolving disputes. Rather, a lot of it depends on what the nature of the relationship is, the nature of the potential dispute, and the nature of who the parties are. Us, as a global aerospace and defense company, we have contracts and operations all around the world. And what we think might be appropriate for a potential dispute or a relationship with a foreign customer in another part of the world, I think is a lot different than our bread and butter U.S. government contracts, where we have a particular approach, and that there's also a particularly prescribed approach within the U.S. government contract arena.
Can you tell us about what your company does to try to avoid disputes?
Well, I think we think about it sort of on a spectrum, where a lot of what we do is performing on reasonably large contracts, sort of agreed upon program with the customer to either deliver a service or build a vehicle or a series of vehicles. And a lot of what we do that avoids disputes is way outside of the law department's purview. It really is about the excellence in operations that our folks bring on a day-to-day basis, and customer intimacy, working with them on the program and identifying potential issues before they working them out. As things move more into a true potential dispute, things might harden into what might be a conflict. And at least we take the position generally, or the approach, that having empowered leaders within the organization at whatever level is appropriate for that type of dispute to sort of talk directly with each other, independent of what the formal dispute resolution mechanisms might be, is typically the way that a lot of these things resolve. It's people who truly understand the interests of the party and who can sit down and talk to each other face to face or over the phone or whatever it needs to be, but in order to sort of really get to the nub of what the issue is and find a way forward.
Assuming that you do move to a formal dispute resolution process, what do you see as the benefits and disadvantages of litigation versus alternative dispute resolution methods?
Well, I think that the Zoom here caught for a moment, so I'm not sure I caught the entirety of the question, but I think what I'm asking sort of the advantages and disadvantages of different approaches to And a lot of it depends, again, on sort of case-by-case situation with the nature of the matter, the nature of the relationship, and what is, again, what's appropriate for a dispute with a domestic customer, where we might think it'd be appropriate to be in state court or in U.S. federal court, assuming that the overall situation is predictable and reasonable. That might not be appropriate for an international contract or an international situation where we don't necessarily want to be in foreign courts. I guess the way that we think about it, or at least that I think about it, is that we are sort of looking for a couple different elements in whatever dispute resolution forum we have. We want something that's reasonably predictable, something that can handle the degree of sophistication of the nature of the relationship and the potential disputes related to it. And we want something that can be predictable in the sense of it does not, the way that the forum operates will be something that we can sort of understand up front and sort of manage through, rather than something that may change on a case-to-case basis and make it impossible for us to sort of predict and understand. And partly that's in order to better manage litigation, but it's also partly if you understand how dispute might be resolved through litigation or through an alternate dispute resolution mechanism, you have a better sense of what your alternative is to a negotiated resolution, which again increases the ability to actually reach a negotiated resolution, because clarity of what it's going to look like if you actually have a go through with the dispute. Have that clarity, it becomes very, very difficult to sort of understand what your options and alternatives are, and that can raise the costs or difficulty of sort of getting to a negotiated resolution.
And has the COVID-19 pandemic changed or not changed the nature of the disputes that your company has seen? And has the pandemic changed or not changed the way that your company manages dispute risks?
I don't know if it's changed the nature of the disputes. It's certainly the pandemic, like with our business, like almost any business, has been impacted by the pandemic, by the increased the different things that you had to do in order to respond to COVID-19, the social distancing and the like. Obviously, our ability to travel and go address problems has been significantly restricted over the last 15 months. With that, and obviously some of those things have led to or created the potential for disputes in terms of paying for increased costs or in terms of delays caused by COVID-19, but none of that has changed the fundamental nature of what the disputes are. It might have changed sort of what led to something in a particular instance, and it also may change the way that we're able to address it, since it's harder to get to someplace in person or harder to sit down with a counterparty, or at least it has been for the last 15 months. And as things are lightening up here, hopefully we'll be able to get back to a little bit of business as usual.
And have you had experience with virtual hearings or mediations, and what's your view of them?
So, I think that's been one of the most interesting things of the last 15 months, is that we've learned that virtual hearings and the like work, or at least work to some degree. We've had external counsel participate in virtual hearings of different different types, and from depositions to different hearings, and they have been more effective than I thought they would be. But at least in my view, there is something that is essential about in-person communication that is necessary, especially for the most sophisticated disputes, but even for almost anything getting to the ground truth. It's much easier to do so in person, where you have the fullness of that communication. So look, I can't predict what virtual hearings, how they will, what role they'll play going into the future, but I do think it would probably be unwise to try to wholesale replace the process of in-person meetings and in-person hearings with fully virtual ones. But it does appear that this is a very helpful tool in the toolkit for mediators or arbitrators or anyone trying to conduct legal business, to have that as an option, the virtual hearing or the virtual meeting.
And I'm so glad that we now have the Zoom technology that we can have this virtual meeting we're having now.
Yeah.
I'd like to change tact a little and now focus on your personal experience and your personal journey. So you've been a partner at a law firm as well as in-house counsel. What are a few things that you think external counsel should understand about in-house counsel?
Well, I think probably one of the things that is most, and you see this both from the, or I saw it at least, both from the in-house perspective, but also as external counsel, is that often well, one, in-house counsel is hiring external counsel because they're more skilled at what they are doing than in-house counsel, and they are hiring them for a reason to do those things, and that's important. But on the other hand, in-house counsel often have a understanding of the business and the business needs and strategy that can help inform the litigation strategy or the matter in a way that can be extremely valuable, even if they cannot put those that understanding into the format or the words that sort of would go along with whatever that litigation forum is, and to spend time sort of interacting with and thinking about and listening to in-house counsel can help clarify and improve the advocacy of outside counsel by better marrying that strategy and advocacy to the business needs and interests of the company.
And what's your advice, especially for younger external counsel, to try to better understand their client's business strategy and commercial priorities?
Be curious. I think be curious both in meetings with in-house counsel, be curious in meetings with the more senior lawyers that you're working with. Ask why, what are the needs here, what are the interests, and also be curious outside of the case, right? The internet provides more information than you can ever imagine about almost every business that you probably work for as a young lawyer, and you can learn about the industry, about the business, and then just keep being curious and learning, and a lot of that will give you the opportunity to ask more questions and to learn more.
Would you recommend doing a client secondment?
I think it depends a lot on the circumstances of the secondment, on who is, on what you're being asked to do, on where you are in your career. I don't think that there's a one-size-fits-all answer to that. One thing that I do think is certainly the case is that is in the practice of you're not doing what you want to be doing unless you're doing it. So if you want to be an international arbitrator, go be an international arbitrator. Don't try to do other things in order to build up some experience, because if you're not doing it, what you've done is just not the same thing. It will not have the same experience. And it is so easy in this practice of law to get sidetracked on different things, and the long game can end up getting you way off into doing some other type of law. And maybe that's something you want to do. You should certainly follow whatever wonderful opportunities your career may present to you. But to the extent you know what you want to do, you should go.
And do you have any advice for those seeking an in-house career?
Well, I think I think the main thing is to make sure to understand the in-house situation and the in-house, the circumstances of being a lawyer at that company. Not all jobs are the same in-house, and not all opportunities are the same. And I think a big part of, if you look at, according to recruiters and others, a big factor in success of people going from external counsel to in-house counsel is the degree of relationship between the law firm that the person is coming from and the company. And I think that's probably true because people have a better understanding of the cultural demands within that company. They have people who know each other on both sides that can help acclimate the transition. And it probably means there's a little bit more intimacy as between sort of just an understanding of how that business may operate. And that isn't to say that you would not succeed moving from outside counsel to in-house at some other place, but just the data seem to suggest that type of familiarity is extremely helpful. I'd say the other thing to make sure to understand is what you're getting yourself into. Certainly, some in-house jobs are extremely rewarding and extremely rich with legal challenges and business challenges, but others can be extremely challenging and present sort of very difficult circumstances that are similar to or being outside counsel, and to sort of understand how that particular company works and what the opportunities are before sort of jumping in.
And my final question for you is, what is your advice for external counsel, especially those looking for partnership, to find new clients and to build a client base?
At least in my view, probably the number one differentiator for people who are building or for people like me looking for outside counsel is knowing that you've got someone that you can trust and rely on and that is accountable to you at the law firm. And if you can be that person in investing in relationships, both with people that are already in-house, but also peers within your law firm, peers within your network or within your legal community, over time, that will be a way to build a durable and reliable, book of business, is having people that know that they can pick up the phone and call you, and you will ensure that they get the right advice from the right people, and make sure that that work gets done on time and in an appropriate way. And also that you're the type of person that would say, we cannot do that, and find another opportunity in the future to work together. But I think that's the one of the at least in my view, most reliable ways to build a durable book of business is to be somebody that can be trusted and counted on by folks who are interested in buying legal services.
Thank you so much, Nick. I have learned so much through our conversation, and I know that our audience will find your advice and experience invaluable. We're very grateful for your time, and we thank our audience as well for tuning in.
Thank you so much. I appreciate it.